2 more federal circuit courts uphold the felon in possession ban. Plus, the ATF responds to questions about masked agents conducting operations. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome back to the news update. I'm contributing writer Jake Fogleman, joined as always by Reload founder Stephen Gutowski. TheReload.com, of course, is where you can head on over today to sign up for our free weekly newsletter. It'll keep you up to date on all things happening in the world of gun politics and policy. To kick things off this week, we want to talk about a pair of rulings dealing with one of the hottest button topics in gun law in the last few years, starting with a Fifth Circuit panel decision that came down upholding the felon in possession ban, the federal felon in possession ban, as it relates to someone whose predicate offense didn't really have anything to do with firearms whatsoever.
Yeah, and wasn't an intentional act of violence, which is interesting. However, it was something that I'm sure a lot of people would consider quite dangerous, right? This was a reckless driving incident that this defendant was involved in, where he had run a red light at 107 miles an hour, and he crashed his car and ended up seriously injuring 2 people because of it. And essentially the Fifth Circuit said, that's dangerous enough, right, to meet the standard that was kind of extrapolated on in Rahimi, where, the Supreme Court is interested in, or appears to be interested at least, in this idea of somebody has to be shown to be dangerous to disarm under the Second Amendment. And in this case, the Fifth Circuit said, that violation is serious enough and presents enough of a risk to society that this person can be disarmed. So it's just sort of an interesting one to see in terms of these gray area maybe cases, these cases where it's you don't have somebody like Rahimi where they they physically assaulted their significant other or shot at them or done a bunch of other dangerous things, at least been accused of a bunch of other dangerous things. And this isn't Brian Range, right, out of the Third Circuit, where he committed food stamp fraud, right, in the 90s, and is not really a danger to anyone physically, certainly, given his criminal record at least. And so this one's kind of more in the middle, this isn't a gun crime. It's not an intentional violent crime. It's more a reckless crime. But the Fifth Circuit has concluded that still can make you dangerous enough to disarm.
Yeah, which is interesting because it's the Fifth Circuit, like you mentioned, Brian Range. So Brian Range in the Third Circuit obviously was the only circuit court to date to actually strike down the felon in possession law. But the Fifth Circuit, if listeners will recall, has at least blessed the idea that certain as-applied challenges from nonviolent felons or non-dangerous felons in their estimation, can go through. And so it's always interesting to see rulings come out of this particular circuit where they're trying to adjudicate whether or not someone is nonviolent or non-dangerous and which ones of those as-applied challenges might succeed. And in this case, as you said, I guess a reckless driving predicate offense just won't make the cut at least under the Fifth Circuit's reading of that standard. So it's always interesting to see those courts.
Yeah,
sort of
the individual circumstances of this case, they didn't think met that. And, this is another one. It's like Rahimi in the sense that in Rahimi's case, he was also facing a bunch of pending charges for this crime spree that he was accused of going on, which is what led to the police finding his gun in his home, because they searched his home after he had shot at several other people, including in a Whataburger parking lot, where after his friend's credit card was declined. So I guess he was very hangry at the moment. But regardless, if he'd convicted on any of those charges, he would have been disarmed anyway under different statutes. Similar case here, where this guy, the reason they found that he was possessing a gun is because they searched his house after a domestic violence incident. And so if he's convicted on the domestic violence incident, he also would be disarmed for that reason too. So it's, this is more of a legal question, less about the individual themselves and more of a legal question about, is this reckless driving offense that this guy had enough to overcome the Bruin test for the Second Amendment rights of this defendant. And that's where the answer is interesting. So I have a little bit of a cold, I think, or something. I think you do too. So it might be a little bit of a scratchy episode for you guys. Sorry about that, but we'll power through it. And so it adds to that lower court case law on this question, and I think you're going to continue to see a lot more cases like this out of at least some circuits where they've blessed the idea of as applied challenges. I think most of the facial challenges haven't worked on this law, right?
Right. Yeah.
But the as applied ones are the more interesting ones to watch. And you've even seen, there was a judge in the Fifth Circuit a couple of years ago, right after Bruin came down, where he had found a defendant was not dangerous enough to be disarmed, even though his initial offense was like manslaughter. He killed somebody in a bar fight, but it had been decades since then, and he argued that the guy was no longer a threat to society, which is something you see some gun rights advocates arguing generally, that if somebody has served their time already, then they shouldn't be disarmed, or if they're too dangerous to own guns, then they should still be in prison. It's something you will hear from gun rights advocates, at least some of them. But there have been very few judges have kind of taken that view. More of them are assessing things in the same way that the circuit is. And then it's always interesting to see which side they come down on. And then, of course, we have another case that builds on this, where you can kind of throw out some of what we just said, because the Second Circuit also has ruled on a similar case, but in a much broader way, right?
Yeah, I was going to say that this ruling is more on the flip side of you've seen in terms of the circuit split, where the bulk of the circuits now, and now the Second Circuit has just added itself to this side of the ledger, has basically just said that, across the board, categorically, the government can disarm you because you're a felon just by status. So categorically, all felons can be disarmed. History and tradition supports it. I will say I'll give the Second Circuit a little more credit than some other circuits who have just said, like, well, we don't think Bruin specifically said no, so we're just going to say that it's categorically okay. The Second Circuit at least tried to do a full Bruin analysis to uphold it. But
I don't know how much credit people are going to give him for this one.
I was going to say, but with the caveat being the Bruin analysis that they relied on to uphold categorical felon bans is pretty much all of the ugly, racist, bigoted, grotesque historical laws that have come up, over the years that we've been covering this stuff, historical Native American bans, bans on Catholics owning guns, bans on free and enslaved blacks from owning guns. And so they relied on a lot of these quite grotesque historical laws to say, look, we're not endorsing those laws, but they do show that legislatures had the ability to ban people based on status. So therefore, the felon ban is okay.
Right. So the idea here is not that you could still ban people from owning guns based on their race or religion, because the 14th Amendment prevents that. But it sort of goes back to the historical analysis, and they claim, well, you can't just ignore these laws because they're, bigoted, or they wouldn't be constitutional anymore today. They still show you something about the history of gun regulation. And that something is that legislatures can categorically ban people they think are dangerous, inherently dangerous from owning guns. That's the conclusion they draw. Now,
right.
Most courts have shied away from going there with these kinds of bigoted laws because, well, I mean, I think it's fairly self-evident that they don't. Most people don't think there's value in these bigoted laws, and I will say that this did come up a little bit in Rahimi in the oral arguments at the Supreme Court, where I think it was Justice Thomas asked the DOJ, who had used similar reasoning in their lower court briefs and then stripped that out in the Supreme Court brief, probably because they didn't think it was going to go over well with the Supreme Court. And that's essentially what he said in oral arguments, that, you got rid of this. Why, did you think it wasn't going to be persuasive here. And so I'd be very surprised if this case makes it to the Supreme Court, if they were in agreement with the way the Second Circuit has gone about doing this. And I mean that sort of the pitfalls of the reasoning are extremely obvious, right? Because of exactly how this reasoning was used in those laws, is that you can basically just ban anyone from owning guns and strip them of their rights based on things that aren't indicative of whether they're actually violent, right? In the founding era's case, their religion or their race. In this case, their status as a felon. And certainly I don't think that the Supreme Court in Rahimi or for instance, with Barrett and Cantor, buy the idea of categorical bans that just because a legislature says this certain group of people is too dangerous to own guns, I don't know that they're going to be on board with using that in place of an individualized examination of the person's actual background. That's certainly what they did in Rahimi, right? Is go through and say, well, this person has been shown through court proceedings to be dangerous. They didn't set an explicit standard for where the line is on dangerousness, but they sure seem to think it matters. Whereas this Second Circuit opinion is essentially saying it doesn't matter. That as long as Congress says you're dangerous, you're too dangerous to own guns. Like, it just doesn't matter what your individual circumstances are. So a very broad ruling, but one that I think is unlikely to survive scrutiny at the next level. If it ever gets there, it would be the big caveat.
That's the $1 million question.
Yes. The Supreme Court has been uneasy about taking up these cases. And in fact, interestingly, this guy in this case, we haven't talked about what he was accused of, right?
Yeah, that's true.
This is, he's a very colorful figure, to put it mildly. He was convicted of fraud, of bank fraud, and he was defrauding people to the tune of a lot of money too. I think it was hundreds of millions of dollars was what it was alleged over like a decade-long period of just getting fraudulent loans from banks and then underreporting his income and on his taxes. So he was evading taxes as well. So a lot of money. So financial crimes, right?
Yeah.
Like white-collar crime stuff. And this is usually where, like Range, he lied to get some food stamps, this guy. On the scale is probably on the more extreme end of fraud, but not a violent crime, certainly. I think there was a witness intimidation.
It wasn't what he was convicted of, but there was some allegations of some other stuff. But
yeah, so maybe if you're analyzing this guy's individual record, there may be some complication due to stuff like witness intimidation, which can involve threats of violence, right? We don't know the full details on that front in this case, but so maybe it complicates it a bit more. But this guy is closer to a Range type situation. He was like a former strip club owner. He now has a big social media following where he sells pickup artists dating advice on his website, and is a big Trump fan. And in fact, and this is kind of an interesting bit to it. Like he put out a press release, not something you don't normally see from a plaintiff or defendant in a case like this, but he put out a press release where he said he was going to continue to fight this case even up to the Supreme Court, and said he was doing it on behalf of Donald Trump because he was claiming that he was railroaded in a similar fashion to how he thinks Donald Trump was. And one of the interesting bits there is that Donald Trump's DOJ doesn't want the court to take up cases like this, right?
Right. Yeah. We've covered this in the past is in a series of, legal briefs and decisions they've made to not appeal certain cases. They're essentially
like the Range case. Yeah.
Like the Range case specifically, basically all out saying, hey, Supreme Court, don't touch this issue at all. We think it's fine as is. We don't. Yeah. The limited ruling, the Range ruling is so narrow that it doesn't upset anything. And we think we should just leave it as is. So Donald Trump's DOJ doesn't seem to share this guy's enthusiasm for taking this up to the Supreme Court.
Yeah. So a little bit of irony there. And of course, Donald Trump himself is is a convicted felon on a nonviolent crime, right? His crime didn't involve violence either. So this guy is right in that there's some connection there. And if he were able to set a precedent at the Supreme Court, it actually would legally affect Donald Trump himself potentially. But yeah, but interestingly enough, DOJ does not seem to want that to happen. The DOJ has been more adamant about filtering these kinds of cases as well, in theory at least, through their rights restoration process that they've restarted. But hasn't been any progress on that one since the first batch of 10 people. So, we'll see what becomes of that down the line. But anyway, it's interesting to see those two cases come out at the same time. They both basically conclude the same thing, that these bans for these individuals were constitutional. It's just the Second Circuit went way further than the Fifth in this case.
Absolutely. But speaking of the DOJ, at least one of its agencies, you've done a little bit of reporting on some of the activities of the ATF. We've seen other agencies as well, like ICE, engage in similar behavior. And that is, while engaging in raids and doing actual, federal government operations, we've seen many pictures and images and videos of agents being masked up on the job, obscuring their face while they're, serving search warrants or going to arrest somebody. And you've actually been trying to contact the ATF, and I think you got a response about what's going on with the agents that are covering their faces.
Yeah, we'll have a story out about this later today. But essentially it only appears to have happened in one incident from the ATF. We've seen it a lot from ICE, right? And there's been a lot of attention around this, a lot of scrutiny around it. And ICE officials have spoken out about it and defended the practice as necessary to protect agents is their line on this. They've gone to they've even asked publications to try to blur the faces of agents during reporting on them. The ATF has not been nearly as aggressive on that front, and they don't appear to have done this nearly as often. But we did see it in local reports from CBS News, the local CBS News affiliate in Minneapolis, and a publication called Riot Unicorn, which I think covers sort of on the ground protest movement type events. And excuse me. And in Minneapolis in particular, which was a raid that does appear to have been focused on a drug and firearm related crime, or like accusations of drug dealing and illegal firearms appear to be at the center of that particular raid, even while it involved a lot of different federal agencies, the FBI, ICE, ATF, and there were at least a handful of ATF agents there who were wearing masks that obscured their faces. Obviously something that could raise concern among, I think, gun owners and gun rights activists, given the relationship between ATF and gun owners in the past and a lot of the criticisms the agency has gotten over things like the Waco raid. While that was obviously quite a long time ago, it's still something that you see brought up a lot in the gun rights community. But anyway, I wanted to just see, is this a new practice? Is this going to be something they're going to do more often? And so anyway, I got a response from the ATF on this from Tanya Kebog. Apologies if I'm pronouncing that incorrectly, which is a spokesperson for the ATF. And they said, quote, ATF agents wore masks during the Minneapolis operation due to chemical agents being deployed and to protect themselves after members of the crowd spit on them. ATF does not typically operate in crowd control environments, and agents deployed the PPE they had available in response to the evolving situation. While not standard, agents are authorized to use personal protective equipment when safety conditions warrant it. Following the incident, they were advised to carry PPE during enforcement actions in case similar conditions arise. Our focus remains on agent safety and accountability during lawful operations. So that's what the ATF had to say about this Minneapolis raid. This one did not spark the same level of controversy and response that for instance, the LA raid on the Home Depot there, where they were arresting day laborers. This one, and from what I've seen, ATF has been, at least from their press releases, and I haven't seen reporting suggesting otherwise, they have been detailed to these immigration operations only in circumstances that actually involve, their purview: alcohol, tobacco, firearms, and explosives. So like in LA, I think they were involved in arresting a guy who had a Molotov cocktail at one of these what turned into a riot. But they weren't, I don't think, involved in at least I haven't seen any reporting to suggest that they were involved in that initial raid at the Home Depot that caused things to spiral there. So, ATF has been involved in these immigration enforcement efforts, but obviously not to the same degree as ICE, and they aren't doing some of the more controversial tactics that ICE has been doing. That's at least sparked a lot of criticism. But certainly they, in this particular situation, and if you look at the pictures and the video from the scene, I don't see a lot of smoke there, chemical agents. Like, not everything gets captured in the few pictures and videos that we have, of course. So, ATF claims that there were chemical irritants used, I think, for crowd control. That may have been the case, and that's why they said they're wearing masks. Of course, you can also see in the videos and pictures, and like these, again, it's limited stuff. I wasn't on the ground there, so I don't know the full details. But there are FBI agents and local police who weren't masked alongside the ATF agents who are masked and ICE agents who are masked. But bottom line, ATF is saying this is not standard procedure. It's not a new tactic that they're rolling out. It's just something that occurred at this one particular raid, and that they've advised the agents to use different PPE, or to have PPE, I guess more like gas masks in the future would be more obviously. These guys are wearing basically gaiters if you look at the pictures, which I would imagine doesn't provide a whole lot of protection against chemical irritants or spitting or what have you. But they're saying that's what they had available, so that's what they used. And in the future, I guess if they're going to be involved in, what happened here is there was a raid, and then the community found out about it and started to surround the officers and yell at them. It appears mostly, yelling and a little bit of scuffling back and forth between protesters in Minneapolis. Obviously in LA, things escalated further than that, to where like Waymo cars were set on fire and bricks were thrown at officers and things of that nature. Happened at least sporadically during the LA situation, turned into more of a riot. And there was looting as well, I know, at certain points. It didn't appear to rise to the level of like 2020 or 1965 or 92 or things like that, but there certainly was some level of rioting going on in LA. I don't think that happened in Minneapolis. It was more like yelling and pushing and shoving from what I've seen of the reporting out of there. The FBI came in basically full military garb with armored personnel carrier type vehicles to carry out this raid. So I don't know. These situations are also very difficult, I think, to pin down exactly what's going on, because I think either side wants to give you the most extreme narrative of what's happening in these things. Certainly the LA situation wasn't entirely peaceful. I think that's clear. But I also, the whole city wasn't burning, and it wasn't to the level of, like I said, even 2020 or 92 or 65 or some of these other well-known riots throughout history. And but either way, I wanted to get some answers on you see the ATF agents in masks. Obviously, it's been a very controversial thing with ICE. Wanted to at least try to understand what the policy is at ATF for this, if there is like a written policy in it. I don't think it's illegal for them to do this, certainly, but obviously people will question the tactics and the image that sets off of hiding the identities of police officers can be justified in certain circumstances. I would think most people would agree, but people I think also would largely oppose having secret police where they're anonymous and you don't know who law enforcement agents are. That's another obvious pain point, I think, for most Americans, and especially for a lot of gun rights activists, particularly in relation to the ATF itself. So I thought it was important to get some clarity on exactly what happened there. So that's what we have. ATF says this was not some sort of new tactic they're using. It was based on the circumstances that unfolded in Minneapolis, sort of an ad hoc situation where the agents felt like they, I guess, needed to put on a mask to help alleviate some of the chemical irritant effects. And also, I guess they claim that agents were spit on. And so, people can judge for themselves. That's what the ATF has said. And so they've given us at least some explanation here.
Yeah, we'll have to see as these things progress, whether or not that explanation holds and that it is just a kind of a one-off situation. And we'll have to see how, if this becomes bigger news, whether or not gun rights advocates start to speak out about it.
Right. And I haven't seen it before this or since. I mean, look, I'm sure there's situations where you're raiding somebody's raiding an enclosed area house or something where they have reason to believe there's some sort of danger waiting for them on the other side. Masking I think in Waco, they wore masks. I remember correctly, some of them. So, I don't think it's an unprecedented thing or always wrong. It's just the question of proper use, I guess.
Moving on to another story that actually directly impacts you, Steve. We had an announcement from the Pennsylvania Attorney General, Dave Sunday, who's actually a Republican, that the concealed carry reciprocity agreement between the Pennsylvania and the state of Virginia, after it was sort of publicly severed a few years back, is now back in effect. And so Pennsylvania will officially recognize Virginia concealed carry permits and vice versa.
Yeah, well, so Virginia obviously is or I guess for people who don't know, Virginia passed a law several years back that where they recognize all other states' permits. And there's a number of states that do that now. But yeah, and around that same time is actually when Pennsylvania revoked the reciprocity deal it had with Virginia. It was actually done by the current governor, Josh Shapiro, who was Attorney General at the time. And it was actually he had done like a review of these reciprocity agreements that Pennsylvania had. And he singled out Virginia. He claimed that the background check system for permitting in Virginia was too different and too lenient compared to Pennsylvania's. And that's why he was cutting off reciprocity between the two states, which had existed for 5 years prior to that. But yeah, now the new Attorney General comes in and does his own review and says there's no conflict that warrants in not recognizing Virginia's permits. So that's where we're at. Obviously, this was something that gun rights advocates have been pushing for in the state. We saw, I think, Gunners of America had a quote out on this, celebrating the win there for what they were trying to pursue, and it also comes as, I think, anyone who's longtime listeners or just anyone who listened last week, right, will know that this came after the Attorney General Pam Bondi had sent a letter to Sunday, and then also the head of the Pennsylvania Sheriff's Association, basically complaining that a lot of sheriffs in Pennsylvania won't issue non-resident permits, and warning them that she thinks it's a violation of the Second Amendment and the Privileges and Immunities Clause, and that she doesn't say she's going to file suit, but there's sort of an implicit threat that DOJ may take some legal action on that front. So I don't know if that's related or not. Obviously, this only helps people in one state who already have a permit from Virginia, but certainly related topic there. And funny enough, both impact me directly because I have a Virginia permit and I have a Pennsylvania non-resident permit, and I have run into the annoyance of having to try and find a sheriff who will actually issue a non-resident permit, especially mine expired in 2020. So, that the pandemic compounded the issues of trying to get sheriffs to issue non-resident permits. But yeah, now I guess my non-resident permit in Pennsylvania is kind of pointless to have, but I suppose I won't have to renew it again. I actually like the physical permit better from Pennsylvania than Virginia, because Pennsylvania they take your picture and they put that on there, but they also like laminate it for you. It's like it's almost like a driver's license type card that they give you. And Virginia, they give you a freaking piece of, like construction paper, basically, that you're supposed to keep for 5 years.
Oh, that's interesting.
And then DC doesn't even give you a physical permit at all. They just email you a PDF, even though you need to keep, you have to have it on you if you're carrying in DC. But they don't even like bother printing out a piece of paper for you. So every jurisdiction's different in how they treat it. But yeah, so significant news there's almost 1 million. I think it's 750,000 or so Virginians who have a concealed carry permit. They will now be able to lawfully carry in Pennsylvania without having to get a non-resident permit first.
Yeah, significant expansion, at least, like you said, for one state's residents in terms of non-resident gun carry rights. But getting into some of our Outside of the Reload newsletter links this week, speaking of, as we talked about at the top of the show, the Supreme Court and its uncertain appetite for new gun cases. We have more evidence to that effect because actually kind of an unusual step last Friday, as of this recording, they did a strange Friday night orders list that they don't typically do. They usually wait for Monday or Tuesday. And in that orders list, they decided to deny certiorari in the Hansen case, which concerns DC and its magazine capacity ban. This was an interlocutory case, so it was up on preliminary injunction out of the DC circuit. So perhaps maybe not a surprise, and maybe not a surprise at all after they denied Ocean State. But it's just another data point to suggest that they're not interested in taking a hardware ban case.
Yeah, certainly not at an interlocutory stage. The preliminary injunction stage, they just don't want to touch them. And as we had a great guest last week on the interview podcast with SCOTUS Blog's new editor, and he was saying, that's kind of how they're supposed. I guess ideally how they would operate is to not take cases until they get to the final merits, but obviously they do that all the time. So it's probably a bit of cold comfort for gun rights advocates to say that, like, this is how they tend to operate most of the time, is not take these preliminary injunction type cases. And they like to wait until, honestly, ideally they want to wait until there's some circuit split in the lower courts, which we've talked about before, right? Some of the problems that gun rights advocates face because of that, because most of the laws they want to take off the books are in states that are overseen by very liberal circuits. And so you're much less likely to achieve a circuit split anywhere along the way because the conservative circuits don't get a shot at these cases. So, but that's kind of one of the realities of how that works. And so, the court is not inflexible on these things. They don't adhere to a completely rigid set of standards for how they decided to take up cases. But yeah, so there's another one where it's like, it's not a surprise that they didn't take this, but it is another setback, I think, for gun rights advocates, certainly. Absolutely.
And then we've got a pair of state law update stories to bring to you guys. One of them comes out of California. Interesting to see that one of the chambers of the California legislature has officially passed one of these, what has kind of become a new trend, I think, in the gun control movement, to go after so-called guns that can be easily modified into illegal machine guns, which translated just into, straightforward language is essentially a Glock ban. They're really going after Glocks and similar striker-fired guns that can be easily, in their words, easily modified to accept things like Glock switches or drop-in auto sears. And so at least one chamber anyway, as of this recording, has passed a bill that would essentially ban the most common handgun in America.
Yeah, which I mean, it's California, so of course they're doing something like this, but they just don't care about the legal side of it. Honestly, I think that's clear from the legislature. They want to push the boundaries as much as they possibly can on this stuff. And then, it's another area where they're in the Ninth Circuit, which has become less of the most liberal outlet or liberal circuit as it used to be. There's a lot more Republican appointees there now than there used to be, but it's still largely sides with the state in gun cases, almost always. It's just changing a little bit, but it's not totally changed at this point. And so, this is just the problem is that you can convert any semi-automatic to fully automatic. Maybe there's some degree of difficulty difference, but I think it's just the fact that Glock switches became really popular among criminals. And so that's why they're targeting them. But it's, I think it's going to be a hard lift to pass constitutional muster if it ever got to the Supreme Court on this question, because, Heller answers that you can't ban handguns, generally semi-automatic handguns. So I guess the question then would just be, can you ban the most popular brand of semi-automatic handguns? And I would be surprised if the court concluded that you could. In fact, I would wonder if they're not going to run into significant trouble in the lower courts before they get, I don't know. Will the non-banc panel of the Ninth Circuit go to bat for something like this? It's hard to say. I think there's a real possibility that they wouldn't, is I guess what I'm getting at there. But we'll have to see if it makes it through and Newsom signs it. Obviously he's been supportive of extremely strict gun bans. I mean, he wanted to partially repeal the Second Amendment, if anyone remembers that from last year. That kind of went nowhere and he gave up on it. But that's where Gavin Newsom is on firearms, right? So I would be surprised if he signed it.
I would say we will have to see, because it'll mark an interesting test in this new trend. We've seen bills like this introduced in other states, and I think New York, it moved a little bit, but they eventually didn't pass it. You've seen lawsuits to this effect. I think the mayor of Chicago and I think maybe the attorney general in Maryland have each filed separate lawsuits making similar claims against Glock. But if this bill makes it out of California and into law, it would be the first, and I think might put up the green light for other blue states to follow suit. And you've certainly seen gun control groups pushing for this sort of stuff. So something worth watching, that's for sure. And then the other state news we want to update folks on actually comes from a red state, sort of the flip side. You're starting to see a little bit of infighting over the permitless carry push in North Carolina. A lot of gun rights advocates think North Carolina, and I don't necessarily disagree, given political conditions, is probably the last low-hanging fruit state, or potentially low-hanging fruit state, to pass permitless carry. But it seems that the Republicans there have run into roadblocks with members of their own party. Yeah.
I mean, it's probably not low hanging fruit, right? Because they have a Democratic governor, right? So it's not a triple red state, which is where you've seen these permitless carry bills fly through everywhere else. And so now you're hitting that purple state territory where this is maybe the most fertile ground in a purple state right now for permitless carry, but maybe not fertile enough to actually grow anything at this point. So it may well pass the legislature, right? But the governor is very likely to veto it. And then I think they lost their veto-proof majority, right, in the last election.
After last election. Yep. And then now there's even a couple Republicans that are saying that they probably wouldn't vote for it as it goes through. So it can still pass, but they already right there, that spells the death knell for the veto override.
Right. So it doesn't seem like it's going to get through, but you never know. And maybe they'll get some Democrats on board. It seems unlikely at this point, but it could happen. And we'll continue to watch it. But, that I think permitless carry has kind of reached the peak, as we wrote, I think, last year, of where it's going to go for now. You'd have to start to see some real shifts in Democratic attitudes towards permitless carry for it to move beyond the states that it's already in, which, to be fair, like, it's in the majority of states right now.
Yeah.
Now they're
29.
They tend to be the smaller population. Population wise, they're still, I think most people are still in a state that has some sort of permitting regime. But as far as pure number of states, the majority now, are permitless. So, but I think, yeah, you'd have to change attitudes among at least purple state Democrats to see this move further, I think.
Yeah. Or you'd have to see Republicans gain serious ground in new states that they don't currently control. And I don't know if I've seen a lot of evidence of that, at least so
right
far.
Right now, the evidence is going the opposite way. All these special elections, Democrats are dominating in, and the president's polling numbers have fallen back down to where he, some of the more unpopular levels of his first administration. But, you can't predict exactly what's going to happen moving forward. So, generally in at least the last, 15, 20 years, the pendulum swings one way or the other as far as our polarization and partisan split goes. Neither of these parties have been able to hold together majority coalitions for very long. And doesn't appear to be moving that way right now either. So, but we'll see. We will certainly keep track of what happens in North Carolina right in the immediate future. Certainly. I think that's all we've got. You're headed out, right, for your like bachelor trip to was it Nashville?
That's right. Yeah. Actually, almost right after we get done recording this for you folks, I'm heading to the airport. And like you said, me and a group of my friends are just going to go hang out for the weekend. We're actually going to shoot some guns at a range down there and go see some live music at night. And
do you know what you're going to shoot? Is there like a machine gun range there?
They have. I don't know exactly what we're going to shoot yet. I kind of have a buddy that's setting everything up, but I have a strong feeling that yes, we're going to shoot some. I know they have 50 cals for rental, and then they also have machine guns there, and so I imagine we're going to get into some of that.
Have you ever shot full auto before?
I have not, so this will be cool.
It's always fun. Counterintuitively, I actually think those sort of attraction places, that machine gun attractions, are a pretty good place for beginners to go. Like the thing about a machine gun attraction in Vegas or Nashville or anywhere else, a lot of states have them now, is that, an RSO goes in there with you and oversees everything you're doing. Now it's not to say there's no risk involved if you're a first time shooter. There've been accidents at these places before, but compared to just showing up cold at a range and asking to rent a gun or whatever, like you're way more likely to have somebody who knows what they're doing actually oversee you at a machine gun place. And it's much more likely to be more fun because full auto is just a much more fun experience than just shooting semi-auto or pump action or whatever at a paper target. It's just like steel targets are more fun than paper targets most of the time. And any sort of reactive target tends to be more fun. But yeah, if it's your first time with full auto, I think it's going to be a really, really good experience. I mean, as long as you don't think about how much it's costing you.
Yeah. Watching dollar bills fly as the shell casings shoot out.
Yeah, that's more or less what you're doing. But it's I think it's worth it. So good. No,
I'm looking forward to it.
A cool trip. So I'm glad to hear that. I think we're gonna do off-roading on the beach for my bachelor party thing later this summer. I think in August. So I'm looking forward to that. Well, I won't hold you up any further. I'm going to make sure you get to the airport on time so you can go out and have some fun. But all right, man. Well, good luck and enjoy. Stay safe.
Thank you.
And that's all we've got for you guys this week. We will see you again real soon.